Apologies, I'm just starting the recording. Yes, we can see your PowerPoint.
Okay, thank you very much. And thanks for joining me here today. Before starting my presentation, I'd like to thank Professor Olivier Moreto, Salvatore Mancuso, and the other colleagues for organizing this interesting conference and give us the opportunity of being all together in these days. Unfortunately, I had an unexpected situation and I have to leave as soon as I finish my speech. Um,
Lucia, if I can just interrupt you, I just want to say if you're going to leave directly after your speech, we will allow questions when you finish for a few minutes to make sure that everybody get the question to ask if you're not going to return.
Okay. But I don't know if I have so much time because my uncle is finished, is dead.
Okay,
and,
so we're
and
sorry to you. We will then,
I have
we
to
will see when you finish.
Yes.
Okay, good. Continue.
As far as I'm concerned, the management of the COVID-19 pandemic is an emblematic example of how a perfectly lawful action can hide the violation of other legal principles. The COVID pandemic has proven to be a complex phenomenon with intertwined implications for international, supranational, and domestic laws. From an international law perspective, the pandemic shows how important a global management of an inherently global phenomenon is. At the same time, the current international order is weakened by two serious shortcomings. The first is the absence of global rules, above all on the protection of health, for example, from live animal markets to the ability to quickly identify an epidemic. The second is the lack of health and welfare systems developed in all countries. As regards the first aspect, around the year 2000, the process of globalization established itself according to a neoliberal model, which allowed for a tailor-made globalized economy of goods and capital without the need for a global protection of labor, social rights, and the environment. The epidemic has shown that this global market model not only creates threats to health, but is completely incapable of responding to emergency and protecting health. Secondly, the response to the pandemic has shown that a key role is still played by national health services, a system which, based on the idea of health as a fundamental right, must also be ensured by the state through the provision of universal public services designed to satisfy needs beyond the market logics of profit. The necessary starting point is the concept of health and the importance of a global public goods. In fact, health may well fall within the realm of global public goods because both because it cannot be produced as a commodity sold on the market to individual consumers, and because threats to health involve negative consequences on a global level. For this reason, the temporary suspension for patents related to COVID medicines and vaccines before the achievement of global herd immunity demanded by countries as India and South Africa was reasonable. But at the 2021 G20 Global Health Summit held in Rome last May, big pharma's interests prevailed. Indeed, the declaration recognizing the role of extensive COVID-19 immunization as a global public good opens to a timid promoting to use of tools such as voluntary licensing agreements of intellectual property, voluntary technology and know-how transfers. Rather, The declaration confirms the need to strengthen supply chains to enhance timely, global, and equitable access to safe, effective, and affordable COVID-19 tools to boost and diversify global vaccine manufacturing capacity. At least, the declaration has recognized the close link between health and the economy, stating that investing in global health until achieving universal health coverage is necessary because the cost of inaction is orders of magnitude greater. We know in the fight against coronavirus, contact tracing solutions have been widely used and implemented around the world. They consist in a digital identification system for potentially infected people before symptoms emerge, designed through a rapid collection of further information on these contacts to prevent subsequent transmission from secondary cases. It's undeniable that these are forms of social control because they can cross personal data in order to limit mobility on the territory in case of danger of contagion. However, although the highly predictive and real-time analysis allowed by big data represent a strategic resource, especially in emergency situations such as coronavirus, the long-term impact on individuals' rights and freedoms cannot be underestimated. Thus, if on a global level an attempt has been made to move towards citizen tracking solutions, their application on a national level cannot ignore the type of internal economic, political, and social constitution. I refer to the type of political regime. In other words, there is a difference between the Western legal tradition and the Eastern one. The first places citizens at the center of government action, creating spaces of freedom, security, and justice. In the second case, politics is the center of government action as a mechanism for social regulation. From a supranational law perspective, in the European Union, every measure that requires the implementation of citizen tracking mechanisms is always bound to safeguard fundamental rights and privacy principles, even in emergency situations. The problem arises because the fight against the virus has led to the collection of a very large number of so-called particular data, both of infected people and of all those who have undergone swab or serological tests. Moreover, the lack of scientific knowledge about the transmission of the new coronavirus, its containment and prevention, have concentrated the efforts of the institutions on the voluntary isolation and quarantine of infected individuals, as well as on the adoption of extraordinary measures with a severe impact in all areas, from the health sector to the productive and social ones, deeply involving the sphere of human rights, the rights to personal freedom, to freedom of movement, assembly, worship, economic initiative, the right to security, the protection of personal data, and the respect for private and family lives. These rights are all guaranteed through an interaction between the European Convention for the Protection of Human Rights, the Charter of Fundamental Rights of the European Union, national constitutions, and lastly, the 2016 General Data Protection Regulation. This means that even fundamental rights are never considered absolute because there's always a balancing of the interests involved. Among these, the right to health undoubtedly has a central position guaranteed by all the constitutional charters and is protected in the double meaning, individual and collective. Precisely in the general interest in public health assessed as prevalent in the framework of expressed protections, other rights that are not considered prominent in the pandemic situation may be deemed less important. In any case, restriction to fundamental rights must be adopted in compliance with the values and principles recognized by the European Union law. The evaluation criterion, therefore, is based on the ideas of strict necessity, security safeguard, and purpose of general interest, which always, in any case, response to the need to protect the rights and freedoms of others. In addition, regulatory action in these cases must be conducted in compliance with the principles of proportionality and minimization. In other words, there must be a balance between the emergency regulations, the consequent measures implemented, and the objectives of containment and prevention of the contagion. That is, there must be the imposition of the smallest possible sacrifice of the least important right. Remaining from a supranational law perspective, that is the European Economic Area, if on the one hand it's possible to see the abundance of rights and principles for the protection of people and legal relationships, on the other hand, we've seen a strong resistance by the European Union to take charge of the economic and health crisis experienced by its member states. This pandemic showed one of the structural limits of the Union due to the fact that the countries belonging to the monetary union have given up their monetary sovereignty without transferring it to a supranational authority that we could call Europe. Monetary sovereignty is a prerogative of countries that can issue public debt in the currency created by the National Central Bank. These states cannot become insolvent as they'll always be able to repay the securities issued in the currency created by their own banks. Countries that have adopted the euro, on the contrary, issue debt denominated in a currency that's not created by a national central bank. They are therefore in the same condition as a country issuing debt denominated in a foreign currency. Theoretically, this may cause a situation of insolvency of a Eurozone country. For this reason, economists had advocated the issuance of corona bonds that doesn't expose a country to the risk of having to repay loans taken out from another country, because these securities can always be repaid using the currency created by the European Central Bank. After intense pressure, there seems to have been a turning point in the European Union with the establishment of the Recovery Fund, whose money will be collected on the markets from continental bonds issued by EU guaranteed debt issues. Europe has apparently responded to the demands of economists in showing substantial unity through the issuance of common debt securities. However, only over time will it be possible to assess whether all this meets the expectation of a recovery of its monetary sovereignty and the reconstruction of the health and economic systems of Eurozone countries. From a national perspective, in Italy, in addition to the problems related to the health, work, and economic crisis, the fundamental issues concern the rights and the structure of powers, since the pandemic has resulted in the predominance of the executive power over the legislative one. To better understand this matter, it's necessary to start from constitutional charter. The Italian constitution does not recognize the state of emergency as a case in which the chambers can confer the necessary powers on the government. It's an ordinary law that establishes that a resolution adopted by the Council of Ministers declares the state of emergency of national relevance, fixes its duration and extension, and at the same time authorizes the issuance of civil protection ordinances. Based on this law, following the spread of the contagion in Italy, the Council of Ministers in January 2020 declared a state of emergency for a period of 6 months. This resolution was followed by an impressive production of norms coming from the different divisions that make up the public administration, raising several questions. I limit myself to highlighting the most striking problem inherent in the legitimacy of public power. Public power exercised in antithesis to the autonomy of private individuals, needs to be legitimized by the principle of constitutional legitimacy. In other words, it's necessary that the primary law establishes in advance the content of the act, its procedure, the limits, the purpose, and the effect that the act itself is meant to produce. The rationale of this principle lies in the protection of citizens from the interference of public power. In contrast with this principle, the coronavirus pandemic has led to a massive use of rules belonging to a source of secondary legislative production, which have deeply affected the fundamental rights and restricted the freedom of citizens, raising strong doubts about their constitutional legitimacy. In fact, the balancing of conflicting constitutional values is a prerogative of the Parliament included in its legislative function as in Article 70 of the Constitution. Furthermore, the measures introduced during the lockdown have proven to be seriously discriminatory towards some classes of people, affecting their psychological and economic well-being. Think of the children of poor families forced to spend long days within the narrow walls of their homes without even being equipped with digital technologies, the elderly, often left alone in facing difficulties and often unable to overcome them, the homeless, people with no job protection, the situation of prisoners that are not protected by the security measures provided for other citizens. Think of the episodes of domestic violence exacerbated by forced coexistence in absence of effective measures aimed at protecting the victims. Let's finally consider this paradox. That is, if on the one hand the sacrifice of all fundamental freedoms is justified in order to protect the right to public health, on the other hand, the inadequacy of the welfare state, which has allowed increasing expenditure cuts to healthcare services, make us witness the sacrifice of the same right as a fundamental right of the individuals who find it difficult to obtain the necessary health care both for the treatment of the COVID and above all for the other conditions that may affect them. This brief overview of the scale of the pandemic leads us to reflect on 2 points: on our being part of a global risk society and on our being recipients of a global policies. It's clear that the management of this pandemic raises many questions and requires urgent assessment. Let's think of the World Health Organization, the delays, the mistakes, the contradictory information, even the investigation into the causes of the spread of the virus has not provided the satisfactory results. We read about it, likely came from animal, not leaked from laboratory, but we don't know what the animal is. Certainties without clear evidence. In any case, the G20 leaders at the Global Health Summit in Rome last May confirmed their full support for the leading and coordinating role of the WHO in the COVID-19 response and the broader global health agenda. And I think that we have been deprived of our right to a transparent information. We have had contradictory information about the actual effectiveness of the vaccines, on the criteria by which they were authorized, on the EU strategy on vaccines, and others. Last but not least, it's evident that the pandemic is giving rise to political, economic, and social changes that need to be addressed. First of all, with regards to the actual solidity of our democratic systems, since it seems that in this emergency, the requests coming from the population have been almost completely neglected. Secondly, a serious reflection on the real hierarchy of values is necessary also in order to establish on which exceptions and limitations of the recognized and protected rights of citizens may be imposed. Thank you for your attention. I'm sorry, but I have to say goodbye. I hope to meet you again in presence. Sorry, but
Thank you, Licia. We really appreciate it. It was an excellent reflection on all the issues that were brought to the fore by the pandemic. So we wish you all the best with your current family crisis. I hope it's going to go well. And thank you for attending the session and delivering your presentation. We really appreciate it. We will send you emails if we have any questions. Thank you very much.
Thank you. Thank you. Thank you. Sorry. Bye-bye. Bye.
Bye.
Bye-bye.
Thank you. Then we will directly move to this next speaker, that is Gior Fontana Rosa from the University of Molise. You said that you also wanted to share some PowerPoints.
Thanks.
You may proceed.
Okay, I have good morning. Thanks to Professoressa Rautenbach. I have prepared some slides. I will talk about the animal law, the legal status of non-human animals between anthropomorphization of law and dehumanization of society. Introduction, can animals be considered as legal entities and no longer as object of a legal discipline? According to some, the non-recognition of legal personality to animals, but more generally, the inability of the legal system to give equal consideration to other species would constitute a form of discrimination between animal and the human species. The animal question, from a historical perspective, the animal question is old. Think of Emperor Caligula, who appointed his horse Incitatus to the office of Senator. Philosophical and religious thought has been characterized for millennia by anthropocentric culture based on the presumption that the human being is the owner of everything on earth, including living creature. Roman law distinguished things which also included animals and slaves from people who were recognized as a possible holder of interest, therefore or subjective situation and the legal relationship. In Roman law, the classification of entities in terms of person or thing influenced the legal system. Only in the last few decades, the consideration of the relationship between human living being and non-human has changed. The animal is increasingly becoming a point of reference in the lives of many people and families. Some animals, including companion animals, can experience pleasure, pain, and emotion. What is the animal sentience? Sentience refers to the ability of animals to feel, perceive life. In this regard, Article 13 of the Treaty of the Functioning of the European Union states that the Union and the member states shall since animals are sentient beings, pay full regard to the welfare requirements of animals, while respecting the legislative or administrative provision and custom of the European Union countries, relating in particular to religious rights, cultural tradition, and regional heritage. Therefore, Article 13 consider animals as sentient beings, that is to say, as beings capable of feeling sensation, of suffering and pain. Animal experimentation, the position of Italian jurisprudence. Italian jurisprudence has recently dealt with a legal case concerning the use of animals in an experiment carried out by the University of Parma, aimed at verifying the possibility of recovering induced blindness in monkeys. The experiment subject to the authorization involved the use of 6 animals. The ultimate goal is to identify and evaluate a translatable rehabilitation protocol in humans, especially in patients suffering from blindness. The Council of State, Consiglio di Stato, considered that the experimentation was legitimate. However, the Superior Health Council had issued a favorable opinion, conditional on which the authorization could be issued only on condition that every 6 months the data relating to the stress condition detected during the individual phases were sent to the Ministry of Health. The Council of State stated that it is necessary to record the physical and mental state of the macaque because the experimentation is carried out with living, sentient primates. Therefore, University of Parma is obliged to make and file periodic and frequent reports, given that macaque have developed intelligence so as to respect the animal welfare referred to in Article 13 of the TFU. The right to life and dignity of animals. The Supreme Court of India banned the use of bulls and bullocks in entertainment activities such as the Jallikattu and the ox cart race in the ruling of 2014. The judges ruled that animal rights are constitutional rights. Every animal species has an interesting right to life and must be protected by law. In addition, the animal has the right to honor, the right to dignity, and the right to privacy. The right of animals to freedom. Jurisprudence has played an important role in defining the position that animal holds within the legal context. The judgment issued on the matter mainly concern the issue of animal liberation, asserted in court by some animal rights associations in favor of non-human beings deemed to be illegally detained. In 2013, the Central Zoo Authority granted that the status of a non-human person to dolphins and banned their captivity. The Sandra case, the Federal Chamber of the Criminal Cassation of Buenos Aires awarded Sandra, an orangutan from the city zoo, the status of a subject of rights as a non-human person illegally deprived of her freedom. The Cecilia case in Argentina, the court of Mendoza ruled that the chimpanzee Cecilia, as a sentient being, is a subject of law, a non-human person, a non-human legal person who enjoys the guarantees provided by law in favor of human beings. The judge stated that the habeas corpus procedure, which offers protection to a person from arbitrary detention and deprivation of liberty, is applicable in the present case. According to the court, legislative and administrative measures should be taken to end the imprisonment of animals for exhibition and entertainment, because animals are not object to be exhibited as work of art created by people, but rather non-human legal person. Another case, the Chucho case, the Supreme Court of Justice of Colombia decided to grant the requested protection in favor of Chucho, an Andean bear. The judges established the obligation for the Barranquilla Zoo to immediately release and send Chucho to an area that meets the condition of its species. The court concluded that animals are legal entities, insofar they have been legally recognized as sentient beings. However, despite the recent jurisprudential openings in favor of the granting of right to non-human beings, jurisprudence does not seem inclined to recognize them as a real legal subjectivity, because the animal would be unable to claim its right, both in terms of substantive and procedural law. In the United States of America, many legal disputes have involved the request for the release of animals made by non-governmental organizations, in particular by the Non-Human Rights Project. The Tillicum versus SeaWorld case, in the court case Tillicum versus SeaWorld involving 5 orcas in captivity, it was raised a violation of the 13th Amendment to the Constitution of the USA, which outlaws slavery. However, in the present case, the whales were considered not people. The judge stated that animals are not a legal person, and the 13th Amendment applied to people and not to non-person. The term slavery refers only to people, human people, and orcs cannot be considered as such. The Tommy and Kiko case, the Court of Appeal of New York ruled that the chimpanzee is not a person entitled to the protection guaranteed by the habeas corpus, since the animal cannot be subject to duties, nor can it be rights holder. The Hercules and Leo case, two chimpanzees kept in captivity, the NGO Non-Human Rights Project asked the Supreme Court of the State of New York for the recognition of 2 animals as legal entities, and as such, their right to bodily freedom. However, the Supreme Court of New York rejected the request. Another case, Beulah, Karen, and Minnie case, 3 elephants. In this case, the Supreme Court of the Supreme Court of Connecticut rejected the request because that request did not have as its object a freedom constitutionally protected by the Due Process Clause contained in the 14th Amendment to the US Constitution. The Naruto case is very famous and important. The famous judicial dispute concerned the possibility of attributing copyright to an animal. In 2016, the San Francisco court ruled in a lawsuit filed by PETA, a famous organization, against DJ Slater, a professional photographer, that a macaque monkey cannot be copyright owner concerning a selfie. In 2011, in Indonesia, a macaque monkey used a photographer camera to take a series of photos. One of the selfie images had become famous around the world after its publication in the British media. Now, animals cannot claim ownership under the Copyright Act. The judge stated that the monkey could not be held under the copyright law as the author. The judge also clarified that since an animal as a non-human being cannot assume a legal capacity in the trial, it cannot assume nor claim copyright. Moreover, the court ruling did not assign the copyright even to the photographer, thus making the photograph fall into the public domain. The anthropomorphization of animals, despite the recent jurisprudential openings regarding the position covered by the animal in the legal context, the jurisprudence does not seem inclined to consider it as a legal entity because it would be unable to claim its right. The anthropomorphization of animals clashes with the logical and juridical impossibility of equating animals to people. An important case, people versus Fresia case, in 2009, in the People versus Fresia case, the California Court of Appeal sentenced a woman, Katie Fresia, who ordered her dog to attack another woman, Denise Doll, because the owner of the animal had personally inflicted a serious injury corporal to the victim. The defendant claimed that the act that had directly caused Miss Doll's physical injury was a bite inflicted by the dog Papas. The judges recognized the widespread tendency to anthropomorphize animals, particularly domestic dogs. However, the law does not recognize dogs with a state of mind that could incur criminal liability because dogs do not possess the legal ability to commit crimes. Animal rights and human duties in the current health emergency. Recently, the Islamabad Supreme Court ruled on the Kaban case, an elephant detained in the Margar Zoo, claiming that animals can be considered as rights holders. The Supreme Court said the Kaban's pain and the suffering were to end and ordered its release and transfer to a protected elephant reserve. The ruling is very interesting because the court also focuses on the health emergency, stating that the current pandemic crisis has highlighted the interdependence of all living beings. Indeed, in the current context of climate change and the SARS-CoV-2 pandemic, the ecological and health crisis humanity face today are deeply intertwined with the inhuman ways in which humans have always treated animals. It is thought that, for example, 3 out of 4 emerging infectious diseases derive from the phenomena of zoonosis. Wildlife markets, such as the Wuhan seafood market, identified as a possible point of origin for the coronavirus, are a breeding ground for such zoonotic diseases that threaten human health. Animal suffering and antibiotic resistance, a new pandemic for humanity. Animal welfare is closely linked to human survival. Humans systematically inflict suffering on animals in factory farms, laboratory, and the entertainment industry. The most harmful of these practices is industrial farming, rapidly spreading around the world, in which billions of animals are destined to suffer short lives, full of pain and anguish. This activity contributes to aggravating the phenomenon of antibiotic resistance, which, according to some, will represent the new health emergency that humanity will have to face. In addition, animal production contributes to climate change, deforestation, air and water pollution, as well as the loss of biodiversity and habitat. Not all animals are the same. All animals are equal, but some animals are more equal than others. Normally, jurisprudence has so far almost exclusively concerned animals kept in captivity in zoos, and often they were particularly human-like animals, such as monkeys, whales, and elephants. The animal conscience, why animals are not the same, according to some legal personality, should be attributed only to the most advanced animals. But which are the most evolved animals? Those who have a conscience. Conscience can be defined as the ability of a living creature to feel what is happening, to perceive their own body. Well, only some animals would have the conscience, those animals that have passed the so-called mirror test, chimps, elephants, horses, dolphins. Why should the legal system recognize the legal subjectivity of animals? Because animals in various relationships with people have sentience, intelligence, affective needs, feel emotion. On a juridical level, a conceptual change in the vision of the animals is gradually taking place, no longer considered a thing, but equated to a subject. Indeed, the part of the doctrine consider it difficult to recognize the legal subjectivity of animals. In fact, the law considered the animals always from the point of view of people. Therefore, the law is anthropocentric, simply because it was created by man and for man. In conclusion, in our opinion, the process that is leading in almost all legal system to greater protection of animals will continue in the next few years, and is regardless of the granting of legal subjectivity, the attribution of sentience, or the recognition at the constitutional level of animal dignity. However, we believe that this animalist trend constitute a cyclical phenomena, therefore destined to stop its propulsive effect in the legal field when the growing regulatory protection offered to animals began to multiply the legal and no longer just moral duties placed on human beings, or when such duties will begin to be perceived as excessively burdensome by people, when the attribution of rights to animals will result in a burden for humans, or the implementation of the operational rules developed to ensure the concrete implementation of these rights become extremely complex. The protection process could stop, or in any case, suffer an afterthought. Thank you for the attention.
Thank you, Stuart. That was very interesting, much appreciated. I have a question or two for you when it comes to the question and answer sessions, but let's move on to the last speaker, Asha Ostruk from Barbados. Please, the floor is yours, and you can share a PowerPoint if you want to.
Thank you. Good time of the day, everyone. Could someone please confirm that you can see and hear me?
We hear you and we see you. Thank you.
Oh, okay, right. So the dark side of the law of predial servitudes, easements, and restrictive covenants. When you look at those three expressions, you may well ask yourself if they are animals, viruses, or other things, since the topic of our panel is how humans deal with animals, viruses, and other things. Lucia addressed viruses, Siore addressed animals, so it flows logically, given that we are only three, that my presentation is about other things. So are predial servitudes, easements, and restrictive covenants things? In a way, yes. In most legal systems, they are now classified as intangible things. However, I would say that my paper rather addresses the question how humans deal with other humans with respect to such things as predial servitudes, easements, and restrictive covenants, as each category involves the presence of two owners who may have conflicting interests. As I was placed into a panel that is more suitable for the European time zone, I do not expect to have too many common lawyers here. And as European lawyers, you're all familiar with predial servitudes, but probably not with easements and restrictive covenants. So I will give a brief definition of each category to those of you who may need it. All the three address the same social problem, which is the necessity to provide an interest in someone else's property for better use of one's own property, which is solved by different legal techniques of property law in common law and in civil law jurisdictions. So predial servitude is a charge imposed on an immovable, the servient land in favor of another immovable, the dominant land, belonging to a different owner. I took this definition from the Civil Code of Quebec. This notion is practically identical to the common law easement, which is usually defined as a right attached to land, the dominant tenement, that gives the owner of that land a right to use the land of another, the servient tenement, in a particular way, or to prevent the servient owner from using the servient tenement in a particular way. As we can see, the two notions are very similar. Examples of servitudes or easements could be a right of way, the right to walk across your neighbor's land, or a servitude of support, not to pull down your own part of a duplex so as to withdraw the support from the neighboring portion of the house. Both civilian predial servitudes and common law easements originate in the same source, the Roman law. However, their later historic development has been different up to the point of creation in common law in the 19th century by analogy with the law of easements of a new distinctive legal category, restrictive covenants. Restrictive covenant is an agreement imposing a restriction on the use of one's land so that the value and enjoyment of adjoining land be preserved. For example, it could be an obligation not to use one's property for business purposes, not to construct more than one residential house, or maintain the land as an open space. The most important difference from easements is that restrictive covenants are enforceable only in equity and not at common law. Such an institution is naturally inconceivable in civil law, as this tradition doesn't know such an element as equity. The emergence of the law of restrictive covenants in English law, by the way, is a perfect example of a relatively efficient commonization of a purely civilian institution. The nearest civilian equivalent to restrictive covenants would be condominiums, but it is 100% statutory area, so which has nothing to do with common law equity. Created originally to facilitate farming in rural areas, as well as construction and maintenance of buildings in small Roman and medieval towns with narrow streets and densely located buildings, nowadays predial servitudes, easements, and restrictive covenants assist in urban planning and in placement and maintenance of modern technological equipment, pipelines, cables, etc. However, their social function to promote efficient use of neighboring lands and maintain good neighborly relations has remained unchanged. Many properties are burdened by one of the three. For instance, according to the British Law Commission, it has been estimated that in the United Kingdom, about 65% of registered freehold titles are subject to an easement and 79 are subject to a restrictive covenant. I do not have figures for a civil law country, but at least in Europe, servitudes are quite popular as well. After having said all that, you may ask a number of legitimate questions. What could be dark and somber about such a technical area of property law? What could be dark about legal techniques originating in illustrious Roman law that is aimed at resolving an important social problem, the necessity to provide an interest in someone else's property for the better use of one's own and to ensure good neighborliness? However, this is an intrinsic darkness built into the area of law, and it is objective because the function of this area of law is to reconcile conflicts of interest of neighboring landowners. You can see on the slide the two old French postcards that speak about le droit de passage, the right of way, and that portray two very friendly, if not flirting neighbors, including underage children who cannot exercise the right of way in their own legal capacity. However, in many cases, the reality is quite different from these two pastoral pictures. Every landowner will agree with the statement by Frederick Walton, a famous comparative lawyer who worked in a number of mixed jurisdictions. I quote, acts of trespass and supposed trespass, questions of boundaries, questions about trees which overhang boundaries and so forth, give rise to quarrels between neighbors, which are sometimes fought out in the courts with as much passion as if the interests of humanity were at stake. This was said in 1916, but I'm sure that it is still very topical in all jurisdictions from Switzerland to South Africa. The most controversial aspect of the law of servitudes and restrictive covenants is the question of their extinguishment or modification. Once such a right has arisen, it will survive through successful ownerships of the land. And both in common and civil law tradition, it is very difficult to bring such a right to an end. Dominant owners normally firmly object to discharge or modification of such rights. And when this happens, not only does it lead to arguments between neighbors, but it also negatively affects the circulation of lands, their development, as well as to some extent regional damage to regional and even to national economy. So during the remaining time, I will look at the grounds for extinguishment or modification of these rights, and as well as to whether it is realistic to satisfy requirements for those grounds and what can be done about that. The jurisdictions I'm looking at are the United Kingdom and the Commonwealth Caribbean for the common law side, and France, Quebec, and Louisiana for the civil law side. The first ground for extinguishment of easements and servitudes is universal and can be found in all common law and civil law jurisdiction. It is called unity of ownership of the dominant and the servient tenement in civil law jurisdictions, and unity of ownership and possession in common law jurisdictions. And here lies an important distinction between the two traditions. In civil law countries, only the unity of ownership is required, while in common law countries, we also need a unity of possession, because due to the doctrine of estates in common law, an easement is possible in a lease, which is inconceivable in civil law countries. Because a person cannot have rights against himself or herself, an easement will be extinguished if the dominant and the servient tenement come into common ownership and possession. We have a Latin expression that encapsulates this idea, nemine res sua servit, which means that one cannot have an easement over his own land. This ground normally doesn't lead to conflicts between neighbors. From the legal perspective, this is the easiest way to extinguish a servitude or an easement, but it is not always affordable financially. The next ground is release or renunciation, which is also present in both legal traditions. An easement may be released or given up by the dominant owner at any time. It may be implied or expressed. Obviously, an express release should be executed by deed at common law or by notarized act at civil law. In common law jurisdictions, equity will recognize an informal release if it would be inequitable to allow the releasing owner to go back on his word. An example of this would be where the dominant owner has given verbal consent to his light being obstructed, and the servient owner already spent money on building an obstruction. This option naturally is not available in civil law countries due to the absence of equity as a source of law. In French law, if the servitude is reciprocal, the release cannot be unilateral. Both owners must renounce the servitude. For example, for a servitude of support, both owners must release this servitude. There could also be implied release, also known as abandonment. In common law in general, the mere lack of use of an easement, once it has been acquired, will not lead to the extinguishment of this right, because someone is never obliged to exercise the rights which they may have. However, a prolonged non-use may be considered as an evidence that the dominant owner had impliedly abandoned the rights. However, this non-use must be really very long. In Benn versus Hardinge, the British Court of Appeal ruled that non-use, even for 175 years, was not enough on its own to indicate an intention to abandon. The more realistic way to prove the intention to abandon an easement in common law is to demonstrate that the dominant tenement has been altered in such a way that the right claim becomes unnecessary or impossible to exercise. For example, in case of an easement of light, if the dominant owner himself constructs something that obstructs the light, so he may be considered as having abandoned his easement. However, if the dominant owner may submit evidence that the original character of the land may be restored, the easement will not be extinguished. For example, if the building is destructed, you can still construct another building. So the easement of light is not destroyed by this act. In France and Quebec, an implied release of an easement always requires some positive act incompatible with the servitude. However, unlike English law, French, Quebec, and Louisiana law recognize another ground for extinguishment of an easement, which is called extinctive prescription or non-use, which makes the civil law tradition more liberal in this respect. So compare 175 years in the UK with the period of non-use in civilian jurisdiction. In France, it's 30 years, while in Quebec and Louisiana, it's only 10 years. However, the success of this ground largely depends on what must be proven, the use of the servitude or the non-use of the servitude, and the answers are different. In Quebec, the servient owner must prove the non-use by the dominant owner, which may turn out to be extremely difficult, as it is almost impossible to prove a negative act. How is it possible to prove that someone was not crossing my land for 10 years? If non-use is not proven, the servitude continues to exist. The situation in France and Louisiana is completely opposite. In France, the burden of proof rests on the dominant owner. According to one judgment, they must demonstrate that they had exercised the right for 30 years. So you can see it's 1993, a quite a late decision. Louisiana has the same rule, and it is codified in Article 764 of the Civil Code of Louisiana, which says that the owner of the dominant estate has the burden of proving that he or some other person had made use of the servitude as appertaining to his estate during the prescription period. This rule was codified in Louisiana already in 1825, which is much earlier than in France, when the Second Civil Code of Louisiana was promulgated. It was inspired by Louisiana case law, which is a perfect example of mixity of the Louisiana law, when a case becomes a source of an article of a civil code. The case is called Powers v. Foucher, and it was decided in 1822. The argument of the court explaining why the burden of proof should rest on the dominant owner is so clear and sensible that it fully justifies the inclusion of the rule into the civil code. The court stated, the general rule is that he who affirms, the servient owner in this case, should prove. But to this, there is the well-known exception that where the affirmative involves a negative, the burden of proof is thrown on the opposite party because a negative cannot be proved. The defendant, the servant owner in this case, cannot make the proof. It involves a complete negative. So the Louisiana court back in 1822 understood that it was impossible to prove that your neighbor was not crossing your land for so many years and reversed the burden of proof onto the owner who enjoys the servitude. So I hope that Quebec courts will realize the same in the 21st century and will change their approach. The French doctrine also speaks about such ground for extinguishment of a servitude as loss of property. This could be a loss of either the dominant or the servient land because it involves the two properties. It could be either a natural loss as a result of some natural phenomenon when the reinstatement of the lost land is completely impossible. This ground is also recognized in Louisiana. Or it could be a legal loss, which is expropriation for public utility. In this case, even though the land physically exists, it becomes public property, which extinguishes all previously existing rights burdening this land. This ground is also recognized in Quebec. French law knows another ground similar to the natural loss of the property, which is called impossibility of exercising the rights. A servitude is extinguished when the things come to be in such a condition that they can no longer be used. An example could be a drying up of a well, which gave rise to the exercise of the right to draw water. Impossibility should not be confounded with uselessness. A servitude may become useless for the dominant owner, but if it is still exercisable, if it is possible to exercise it, it won't be extinguished. If the impossibility is temporary, the servitude may revive. For example, the well dried, started to produce water again. However, the period for the possible revival should not be longer than the period for prescription by non-use, which is 30 years. These two grounds are not recognized by common law jurisdiction, but there is nothing that prevents them from being recognized if the need arises. However, those two grounds, loss of the property and impossibility, they also do not give rise to conflicts between neighbors, as nothing is left to their will, negotiation, or arguments. These grounds are fully dependent on legal or natural causes. Quebec law recognizes such a ground for extinguishment of an easement as redemption that applies only to the right of way. So the court measures the usefulness of the dominant land against the damage that could inconvenience or depreciation that could be caused to the servient land. So the court could fix the price looking at the value of both properties, etc. But this rule is also not of much help to the servient owner because it applies only to the right of way. You need to compensate the servient owner, and this never applies to the land which is fully surrounded by the land of others, so-called enclaved land. So in civil law countries, most of these grounds do not apply to legal servitudes of public utility, such as the right to lay electricity wires or sewage systems, and to natural servitudes originating in the possession of the land. This is the case of enclaved land. So we have seen that there are various grounds for extinguishing servitudes and easements in both common law and civil law jurisdictions. However, the requirements that one must satisfy are quite demanding, making the cases of extinguishment quite infrequent in any jurisdiction. However, the comparison of common law and civil law rules shows that the civil law tradition provides a better balance of interests of the dominant and the servient owner, recognizing more grounds for extinguishment of an easement and having the requirements that are easier to be met. The conservative of common law and its reluctance toward extinguishment of already existing real rights can also be seen in the grounds for discharge or modification of restrictive covenants. The list of grounds for discharge or modification of covenants is even more limited than the list of grounds for extinguishment of easements. With restrictive covenants, there is not even theoretical possibility to extinguish by abandonment, unlike in case of easements. With the exception of unity of ownership, in order to take advantage of any of the grounds, the owner of the servient land must make an application to the court. And until and unless the court discharges or modifies the restrictive covenants, they continue to exist. The four grounds recognized by courts in common law countries in the UK and in the Commonwealth Caribbean are the following, and I quote from Section 84 of the Law of Property Act UK 1925. The first ground is known as obsolescence, means that by reason of changes in the character of the property or the neighborhood or other circumstances of the case, the restriction ought to be deemed obsolete. The second ground is known as impeding the reasonable user of the land. It means that the continued existence of the restriction would impede the reasonable use of the land without securing to any person practical benefits sufficient to justify the continued existence of such a restriction. The third ground is called agreement. The persons entitled to the benefit of the restriction have agreed expressly or impliedly by their acts or omissions to the covenant being discharged. And the final ground is called no injury to the objectors, which means that the proposed discharge or modification will not injure the persons entitled to the benefit. The legislation only lists the grounds for discharge or modification without specifying any requirements, policy considerations, or guidelines, leaving their formulation to the court discretion. And the case law has been very divergent in common law countries. The list of grounds look precise and promising to the owner of the surveilled land. However, the case law both in the United Kingdom and the Commonwealth Caribbean has taken a very restrictive approach to all grounds, developing the requirements and the tests that are extremely difficult to satisfy. I have looked at the statistics of successful applications for discharge or modification of a restrictive covenant in the Commonwealth Caribbean, and here are my results. Ground obsolescence, 3 successful applications out of 7. Ground impeding the reasonable use of the land, 0 successful applications out of 3. Agreement to discharge or modify, 0 out of 1 application. And no injury to objectors, 1 successful application out of 7. Thus, as we can see, the most successful ground for application is obsolescence. However, even under this ground, less than a half of applications were successful. Some scholars, such as Codellini, express hope that in the future, courts may be more willing to discharge or modify restrictive covenants on the ground of obsolescence. And this expectation is completely justified by policy considerations. Increasing urbanization and the profound changes in the lifestyle of the 21st century make it inevitable that many restrictive covenants imposed on the land in the 20th century will be deemed obsolete by the courts. Also, the private interests of an individual or even of a section of the community should not be allowed to hinder developments which have potential of conferring a benefit to the entire region or even country. For example, urban development, construction of residential houses, promoting tourism, etc. However, the most recent court decisions, such as Southern Golf and Country Club versus Jackman and others, do not support Codellini's expectations. So I'm getting to my final conclusions. Servitudes, easements, and restrictive covenants are very easy to create, but very difficult to extinguish or modify in either civil law or common law tradition. Civil law tradition seems to be more flexible and provides more grounds for extinguishment of the rights in question than the common law tradition. However, both legal traditions need revision of the legislation and/or of the court's approach to the problem in order to ensure a better balance of the interests of the dominant and the servient owner. Finally, just a practical advice to all of you, regardless of the legal tradition. While purchasing a movable property, a real estate, always do a good title search to check if the property is burdened with anything like a servitude, an easement, or a restrictive covenant. And if this is the case, keep in mind that it is extremely difficult to discharge or modify them, and act accordingly so that you don't get first-hand experience with this dark side of the property law. Thank you for your attention.
Thank you, Aisha. Really appreciate that. I don't know much about servitudes, but we did have, I have encountered practical problems with it as well. So the floor is open now. We have 2 papers. The one is on living things and the other one is on untangible things. So you can show your hand, or you can use the icon below with the hand button, or if I still ignore you, you can just start talking. Any questions?
Well, I can probably... Hello?
Your hand is up,
Hello. Hello. Thank you both for your presentations. I was very interested, I must say, in Asia's presentation, as servitudes are a big part of my work too in France. First, I would just like to mention that you talked about usefulness out of proportion in Quebec. Recently in France, we had a case by la Cour de Cassation, which also recognized that it was an important element, as today, I don't know if you know, but in France, we have less and less less and less properties to be bought by young people. And so we devise the land as much as we can. Sometimes the houses are very, very close to one another. And so people tend to have servitudes that prevent the future owners to build anything on the land. And when I say building, it's very large. For example, I had a case last year where the act said you're prevented from building any house, any pool, swimming pool. You cannot plant any trees. You cannot have swings for your kids or anything. So you cannot do anything with the land, actually. And so in such cases now, the judges tend to say that the servitude fails. It's not valid. And that's a new thing in France. So I just wanted to mention that. And then I have a question. So I'm not familiar with common law servitudes and easements at all. Maybe, Asia, you can enlighten me. At the beginning, you talked about the difference between the predial servitudes, easement, and restrictive covenants, but I don't quite see the difference. As you know, in my head, there's only one kind of servitude in France, and then you can, So what's the difference? Really, I cannot. Can you? I believe you know a lot about French law. Can you enlighten me in terms of how would it fit French law, all those categories?
Right. So in France, you used to have, before the codification, you used to have feudal personal servitudes and predial servitudes, servitude prédiale or servitude foncière, right? So the revolution was against that. So they aimed at abolishing the whole category of personal servitude so that we do not make reference to feudal law. Well, the one has survived, like usufruct, habitation, etc., but they are no longer called servitudes in French law. However, they are servitudes, personal servitudes in Quebec law and other francophone legal systems. So for this reason, you have only predial servitudes, right? In common law tradition, the whole word servitude exists, but this is a generic name that groups three things. First, what you call servitude foncière, predial servitude. Second, something which is called in common law, strangely, profit à prendre, which comes from ancient French law, from Norman law, so which is very close to personal servitudes, like the right of the whole village to collect wood, to collect turf, to collect grass, etc. This is called profit à prendre, to get something from the land of another, but you don't have the dominant land. You have people who do that. And finally, restrictive covenants are also servitudes. So, and restrictive covenants were created in the 19th century by analogy with the law of easements, but they are only enforceable in equity. And they are mostly about what you cannot do to your property. So, like, you cannot keep animals, you cannot subdivide it. So normally those are only negative obligations, unless a positive obligation is reciprocal, like you have the common fence and you can paint it or you must maintain it. So again, it's difficult to say exactly what it is in the French law. Some of restrictive covenants will be predial servitudes in French law. Some will be probably, well, we don't use the category of personal servitudes, but those are contractual obligations. They are enforceable in equity, and all equitable interests are discretionary. They are not opposable to the third person who had no notice of it, etc. So definitely you have to use some kind of description to explain a French lawyer what a restrictive covenant is. But yes, servitude includes three things, the word servitude in common law. Predial servitudes, profit à prendre, and restrictive covenants. But I mean, if you want, and I will be happy if you contact me and we discuss the matter in more detail, because I'm interested in the recent developments in France that you have just mentioned. Thank you for your question.
Thank you, Asia. Very clear. Thank you. And yes, we can write emails. Thank you.
Yes, please.
Ignazio?
Yes, good morning, everyone, and thanks to both speakers for their presentations. I have one question for Fiore. It's about the discourse on the anthropomorphizations of animals. You still seem to believe or to have found that animals are things, and anthropomorphization is a technique to extend some protection to them by analogy, rather than changing the nature of animals into something different. Do you have any evidence that somewhere, somehow, animals are becoming different from things, or something between things and humans? It's important because the nature and the rationale for the protection would be different. In one case, is a fiction to make ourselves feel better. In the other case, is we are really giving legal protection to something which deserves legal protection, different from a thing. What do you think?
Okay, the question is, animal is a thing or a person? Initially, the animal, the Roman law considered the animal a thing, but the ultimate trend is toward extend the legal protection to animals. But the nature, the fact is that animal is different to person. The process, the anthropomorphization is still is in trend, but is impossible. Not only but on from point of view, from the natural point and the legal point, it's impossible to give equal consideration to animals and persons. There are many legal institutes think of companion trust to offer legal protection to animals, but today it's impossible. I think that more rights, more duties. It's a simplistic phrase, but more rights, more duties. I think that the process, the actual process, produce more duties for the people. And when these duties, becoming perceived too hard for the people, the animal process could stop. I'm sorry for my bad English.
Nothing wrong with your English, Aisha.
Yeah, may I say something in continuation of this discussion? Thank you, Theora, for a wonderful presentation, and your English is really, really amazing, absolutely clear, you know. And so I have always been fascinated at how the humans are obstinate and persistent in failing to recognize some kind of personality of animals. So the German Pandictists had no problem to create a fiction of juristic person in the 19th century, which is completely unnatural. We cannot attribute the quality of reasonableness or judgment to a juristic person, but this category still exists and thrives, probably because of the economic interest behind the whole thing. However, the humans are failing to recognize some kind of personality of animals, and okay, is it a person? But what kind of person? Is person only a physical person? And in Roman law and elsewhere, it has been always considered as a reasonable person. However, reasonableness have been historically denied to slaves, to women, and the humanity overcame those problems. And we already have Bentham, who says the problem is not whether they are reasonable or not. The problem is whether they are sensitive, whether they can feel pain or pleasure. If they can, we cannot do anything we want to their bodies. And this is, I believe, still a valid argument. And Bentham also said, well, basically a 2-year-old dog or horse is much more reasonable than a newborn baby. And a newborn baby is protected while an adult horse or a dog is not. So, and another comment I wanted to say with respect to your presentation is you looked at the case law, which is perfect, but you may also want to look to codified provisions, because some civil codes, such as the Swiss Civil Code and the Quebec Civil Code, have already amended their provisions with respect to property law. So yes, the animals are still somewhat things, but that have their own rights and interests with respect to if you find someone else's dog, if 2 owners contest the same pet, etc. So, but that's in property law. That is not that much about the tort, the criminal law, etc. But you may want to explore the codified provisions on that. But thank you so much for your presentation. I'm also interested in the question, and it was very instructive for me. So thank you.
Many civil codes and constitutions recognize the animal sentience, but not attribute animal rights, because it's very difficult. Animal sentience, but not rights, human rights.
I think civil codes are not that much about human rights, but at least, you know, a step by step, small step after one step, and then we advance this cause.
In progress.
Mm-hmm.
Any more questions?
I would like to, I'm sorry, go, Lucas.
Yes.
Well, I can also go after you, Celia.
No,
but
no
well, you gave me the priority, so I take it. I do have a question for Fiore. I enjoyed both, well, all 3 presentations. Fiore, you mentioned, based on Roman law, that lawyers, and I say it in the general abstract terms that I heard, we have to qualify anything either as thing or as person. And I'm wondering whether that dichotomy itself, either or 2 solutions, is not in itself the problem, or breaking it might be a solution to recognizing more a different status to animals. What do you think about this?
The tertium genus, the 3rd genus. Some scholars argue that it's possible to create a new status for the animal, nor the animal is not a person, I think, and is not a thing. Some scholars arguing it's possible to create a new status, nor person, nor things. A third status. But it's a specular, it's a doctrinal debate issue.
Celia?
Not normative.
Well, my question was similar to Lucas. Actually, in France, animals are things, but since 2015, there is a new, very small paragraph that says that they are also living, sensitive beings. So they are living, sensitive beings, but they are things straight away, just after the sentence. So maybe many authors have said that this creates a 3rd category: things, human beings, and sacred things. We call them sacred things. You've already answered my question then. One last question though. Do you know anything about the Californian laws that allow you to marry your pet, how would we articulate the fact that animals are things, but then you can marry them? I don't know. It's just I wonder if you know anything about that. Any one of you? No.
In 2015, Civil Code as Napoleon Code has been changed, and now is Civil Code recognize the animal sentience. Not only Civil Code, French Civil Code, but also BGB and many constitutions, Swiss Constitution, Dutch Constitution recognize the animal sentience. In order to the second question, in the USA, the main problem has dealt with the possibility for the people to use the trustee to leave the owner to pets, dogs, for example. There is a legal institute, the trust, that can be used in order to leave the ownership to pets, the companion trust.
Thank you. Perhaps you could contact Celia and ask her for that information about that marriage between animals and their owners. It could also be a good argument to add to your arguments. Ignazio?
Just want to make
I don't know the question of marriage. I don't know.
In Italy, my wife thinks she has married an animal, in fact, just to let you know.
Yeah, that is also true. So perhaps you can just use Ignazio's experience and add that to your to your research. I was going to use my privilege as the chair just to end with one example. In South Africa, we have the Zulu Nation. One of the nations in South Africa has every year a first fruits festival, and at that festival they send young boys on their way to puberty to kill a bull with their hands, and the idea is that they must break the neck without letting any blood. And there was an NGO that went to court and tried to stop this festival, but all the evidence were based on media reports. So the court just ended the case by saying, well, this is not enough evidence to prove that the animal suffered, so they did not succeed with the case. And that could also be an interesting example that you could add to your list of cases. So I have your email number. I will send you something that I wrote on that, and perhaps you could add that as well, because we have, I think in South Africa, mostly the discussion whether your right to culture includes that right to have cultural practices where animals are slaughtered in some or other way. So we are not nearly as close as reaching an agreement that animals can be more than a thing. The South African law in that respect, I think, is more based on civil law than it is on English common law. Does anybody else have a final and last question to any of the presenters? No, then I think we can conclude this session. Thank you, everybody, for being present. If you don't mind, I'm just going to take a quick snapshot. So if you don't want to be on a picture for our record, I would suggest that you close down your video. Right, here we go. Say cheese. I've got it. Thank you, everybody, and enjoy the rest of the conference.
Thank you so much. Bye.
Bye.
Thank you. Bye.
Thank you. Bye-bye.
Bye.
Okay.
Yes, I've got it.
Did well. Very
Thank
good.
you.
And yes, Lucia had a problem because she lost an auntie early this morning.
Yes, she did. She did tell us, and we handled it, so it's no problem.
Very
I've got your nice picture, Ignazio.
Okay, I'll see you later then.
Okay, bye.
Bye-bye.